Transparency International UK estimated that more than 236,000 properties across England and Wales, worth at least £64 billion, are held through trust structures where the true ownership is not visible to the general public through ordinary searches. £64 billion of British property sitting behind structures that mean the person asking who owns this cannot get a clear answer from any public record. And among those structures, investigators using leaked Pandora Papers documents identified a London property network connected to the family of a sitting head of state. Properties worth nearly $700 million, held through 84 offshore companies, spread across some of central London's most valuable addresses. Apartments, office buildings, a historic pub. The family's name did not appear on any of the front doors. Today, 3 families, 3 investigations. 3 different ways that extreme wealth uses offshore structures to hold British property in ways the public cannot easily trace. Case 3. A former president's sister and 5 London properties hidden behind British Virgin Islands companies, revealed only when Britain changed its transparency laws. Case 2. A government agency with court-ordered legal powers that lost its case against one family's offshore property network. And Case 1, the most documented offshore property investigation in British history. A sitting president, a $700 million London portfolio, and the specific legal loophole that meant even after investigators found the 84 companies, 10 properties still disappeared into a trust structure the new transparency laws could not reach. Stay to the end, because Case 1 does not end with exposure. It ends with half the network still hidden. Why offshore ownership is legal and why that makes it more powerful, not less. Before the 3 cases, one clarification that matters. Owning British property through an offshore company is not automatically illegal. Offshore structures have legitimate uses: inheritance planning, international investment, commercial privacy, cross-border business arrangements. The problem is not the structure. The problem is what the structure can be used to conceal. When a £20 million London mansion is owned by a British Virgin Islands company, which is owned by a trust registered in another jurisdiction, which lists a nominee director as its contact, the building is visible, the price is known, and the owner has almost disappeared from the public record. That gap between visibility and ownership is what investigators, journalists, and eventually the British government spent years trying to close. In 2022, Britain created the Register of Overseas Entities, requiring foreign companies owning UK property to disclose their beneficial owners. When it opened, names began appearing that had previously been almost invisible. These are 3 of them. Case 3. The Sarkissian family. Armenia, former president. 5 London properties, 5 BVS wine companies, revealed by 2022 Transparency Register. The story begins on Cheyne Walk in Chelsea, one of London's most prestigious residential addresses overlooking the Thames. Behind one red brick facade stood a 5-story mansion. For years, anyone trying to determine who owned it through public property records would have found a company name registered in the British Virgin Islands, rather than an individual. When Britain's Register of Overseas Entities came into force, and overseas companies were required to disclose beneficial ownership, reporters at OCCRP, the Organized Crime and Corruption Reporting Project, investigated what those disclosures revealed. The Cheyne Walk Company was registered as being beneficially owned by Karine Sarkissian, the sister of Armen Sarkissian, who served as president of Armenia until his resignation in 2022. And that was not the only property. Investigators identified 5 properties in and around London, held through 5 separate BVI companies, connected to members of the Sarkissian family. A second Cheyne Walk property, an apartment near Buckingham Palace, a country mansion at Virginia Water, a central London flat. 2 properties bought in 2006 and 2008 had cost a combined £24 million. Others were valued at several million more. Armen Sarkissian told investigators that he had built wealth in business before entering public office, and that his sister had managed those investments on his behalf. He described the offshore arrangements as conventional professional wealth management structures and denied any undeclared interest while serving as president. And this is where the Sarkissian case matters, not as proof of wrongdoing, but as a demonstration of how offshore structures function. For years, a former head of state's family held £30 million of London property behind 5 corporate names. Not hidden in the sense of physically concealed. The buildings were there, the addresses were known, the prices were on record. The human beings behind the companies were simply not required to appear in any public document. Until 2022, when Britain changed the law. And then they did. Case 3 demonstrated what offshore structures look like when new transparency laws force disclosure. Case 2 demonstrates what happens when the British government goes further, obtains court orders, launches an active legal investigation, and still loses. Case 2, the Nazarbayev family connection. Kazakhstan, former president's family, £80 million London properties, UWOs obtained, NCA lost in High Court. In 2019, Britain's National Crime Agency obtained unexplained wealth orders against 3 high-value London properties. The orders were a powerful legal instrument, introduced in 2018 as part of Britain's effort to challenge suspected corruption through property holdings. An unexplained wealth order does not charge anyone with a crime. It compels the holder of an asset to provide information explaining how they acquired it. If a satisfactory explanation is not provided, the asset can become subject to civil recovery proceedings. The NCA applied the orders to properties connected to Dariga Nazarbayeva and her son Nurali Aliyev, the daughter and grandson of Nursultan Nazarbayev, Kazakhstan's president for nearly 3 decades before stepping down in 2019. The 3 properties had originally been purchased for more than £80 million. They were held through offshore companies. The NCA's position was that money connected to Dariga Nazarbayeva's former husband, Rakhat Aliyev, who died in an Austrian prison in 2015, while facing multiple criminal charges, had been used to finance the acquisitions. The family disputed that position entirely. In 2021, the High Court dismissed the unexplained wealth orders. The judge concluded that the NCA had not sufficiently established that Rakhat Aliyev was the source of the funds used to purchase the properties. The orders were discharged. The properties remained with their owners. The NCA faced significant legal costs. The case is not evidence of wrongdoing by the Nazarbayev family. The High Court said so explicitly, but it is evidence of something more uncomfortable for the British state: a specialized government law enforcement agency. Court-authorized legal powers specifically designed to challenge offshore wealth structures. A 3-year investigation, and the outcome was not enough. If Britain's National Crime Agency, with its investigators, its court orders, and its specialist legal teams, could not establish the source of funds behind an £80 million London property portfolio, to the High Court's standard of proof, consider what that threshold means for any ordinary member of the public, any journalist, or any foreign government trying to understand the same ownership chain without those tools. The mechanism designed to pierce the offshore structure did not pierce it. The offshore structure held. Case 1. The Aliyev family. Azerbaijan, sitting president, $700 million London portfolio, 84 offshore companies, Pandora Papers, trust loophole. In 2021, the Pandora Papers, a leak of 11.9 million documents from 14 offshore financial services firms, gave investigators the most detailed picture yet of how offshore wealth structures actually work at the top of the global wealth pyramid. Among those documents, journalists at OCCRP identified a London property network connected to the family of Ilham Aliyev, the current president of Azerbaijan, in office since 2003. The scale was unlike anything previously documented in a single British property investigation. Nearly $700 million of London property, dozens of prime central London addresses, luxury apartments, commercial office buildings, a historic London pub, and behind the portfolio, an interconnected network of 84 offshore companies spread across multiple jurisdictions, administered through corporate service systems that made the human ownership extremely difficult to identify from public records. 3 of Aliyev's children appeared in the investigation. Close associates were connected to multiple properties in the network. When Britain's Register of Overseas Entities opened in 2022, investigators returned to 23 London properties linked to the Aliyev network. The register revealed that the president's daughters were listed as beneficial owners of 6 luxury London apartments. Names that had previously been invisible in public records now appeared. The transparency reform had worked for part of the network. And then the limit appeared. 10 properties in the Aliyev network, originally acquired for approximately $160 million, had been moved into an offshore trust structure. At the time of the investigation, that trust arrangement meant the public could not determine from available records who currently benefited from those assets. The Register of Overseas Entities had illuminated 6 apartments. The trust structure had absorbed 10 properties worth $160 million and placed them beyond the reach of the same transparency rules. The law changed. The investigation found the network. The network adapted. 6 properties became visible. 10 disappeared into the trust. A sitting president's family. $700 million of London property. 84 companies. Years of investigation. And when the transparency law finally arrived, it reached 6 apartments and stopped at the trust. 236,000 properties. £64 billion. Trust structures, offshore companies, nominee directors, BVI registrations, 3 families across 3 countries, 1 former president, 1 president's daughter and grandson whose properties survived a National Crime Agency court challenge, 1 sitting president connected to the most documented offshore property investigation in British history. And in each case, the same architecture: the building is visible, the price is known, the address is public, and the human being behind the corporate ownership chain requires years of investigation, leaked documents, and specialist legal expertise to identify with certainty. London property has functioned for decades as something more than real estate. It is a store of value in one of the most legally stable and internationally recognized markets on the planet. It is collateral. It is inheritance. It is the conversion of wealth from one form, political, commercial, extractive, into another form that can sit in a postcodes of Chelsea or Knightsbridge indefinitely, appreciating without requiring its owner to ever stand in front of the building. Britain has spent years building the legal architecture to make that ownership visible. The Register of Overseas Entities, unexplained wealth orders, anti-money laundering regulations. The mansions are not hidden. They are standing on the most expensive streets in one of the world's most photographed cities. Next on Blood and Sterling, we go back to the families that have owned London openly for centuries. No offshore companies, no shell structures, no need. Because when your family was given the land by William the Conqueror, and the deed has never expired, the building does not need to hide behind a company. It simply needs to keep collecting the rent. Blood and Sterling. Subscribe.